Please, Your Lordship. Lordship, I seek your kind permission to file a mention memo for urgent listing of a contempt petition, my lord.
Contempt?
Contempt, my
But
lord.
this is not the court of contempt.
My lord, Lordship had passed a judgment 2 days back. That was the Shillong Club matter, my lord.
Okay.
Shillong Club matter, and Lordship had held very clearly, had found that number one, the lease deed of 23 was valid. Number two, that we were in possession as on date of the judgment. That was 17th. On 18th, my lord, yesterday, respondents landed up at the property with workers. They have put up fences, barbed wire fencing is going on, my lord. That is the reason we've come before this honorable court on an urgent basis, my lord, because the finding is very clear, contained in the order. But unfortunately, towards the end, Lordship was pleased to dismiss, use the words dismissed. Appeal is dismissed.
See, whatever the case may be, order has been passed. But
Yes,
I find there was no proper demarcation.
True, my lord. True. So we are not against the order. We are only.
I know, I understand.
Yes, madam. Because the order is in our. If I can submit, my lord, the order is in our favor. Because Lordship has found us in possession, etc. Now, one day after the judgment, they are trying to dispossess us and overturn Lordship's finding, my lord.
Why have you? Is there?
But my friend informed that he is inclined to move the contempt.
What is the?
I don't know for what purpose the contempt would lie.
No.
Lordship has disposed of the appeal, second appeal. Nothing survive here.
So,
Option is there for him to go to
my lord,
Supreme Court.
My lord, the Supreme Court itself is very clear that a contempt is not only a willful violation of a direction or a prohibition. If there is an attempt to circumvent or negate any judicial order, then also it amounts to contempt. So the actions of the respondent conducted one day after the judgment amounts to negating Lordship's order, my lord. And Supreme Court is very clear on this. I have the judgments also.
With greatest respect to
Anyway,
my
then
esteemed
we'll have
colleague.
to.
So we are not against the judgment. We are not challenging or trying to shake or modify the judgment in any manner.
That is
But
why
we are only pointing out.
options are left to them to approach the Supreme Court by way of filing a civil appeal.
If we want to challenge Lordship's judgment, but that is not the case here. We are with Lordship's judgment. We are satisfied with Lordship's judgment. However, the actions conducted one day after Lordship has passed the judgment amounts to negating Lordship's judgment.
Could be. See, that could be a fresh cause of action.
Exactly. Exactly.
My lord, will kindly give me 5 minutes indulgence. The petition is getting filed. If there is no case, I have no
We'll
case.
take it up tomorrow.
My lord,
Your file.
it's in the process of getting filed.
Matter will come up tomorrow.
Yes.
There's some urgency, my lord, because the work is going on, my lord.
Even if there's urgency, what can this court do?
Very well. Tomorrow, my lord. Tomorrow. Obliged.
Tomorrow, Mr. Jindal, because you have to give time to the registry to process the matter.
Naturally, my lord.
So
Naturally.
you just cannot right now and go and hurry them up.
Naturally, my lord. The only
You get this kind of complaints all the time.
the only sword hanging on our hands over our heads is the fact that workers are already there. They're in the process of putting up barbed wires.
Mr. Rizzo, I mean, off the records, you can impress upon your client also, not to act,
But I'll take the instruction, madam. I'll take
not to
the
act,
instructions.
untoward.
But let the matter come up tomorrow, madam.
Yes, you see,
My
caution.
colleague may have a case,
Caution.
but I'm yet to see his petition.
You see,
Lordship kindly
if
examine tomorrow.
any action has been done illegally, then what happened? Repercussion will follow.
We may in the same manner. I'll satisfy tomorrow, my lord. Let the matter come up tomorrow. I'll satisfy.
But for the time being,
Well, yes.
If my senior friend can use his good offices
That's what I said.
just to talk to his clients and
I'll
instruct
take the
them.
instruction, madam. I'll take the
Please,
instruction.
yes, any mission?
Supplementary list, item number 1.
Okay. Yes, who's there?
Your Lordship, it's Mr. V. Kumar is the petitioner.
No local counsel?
No, Your Lordship. Your Lordship, in these matters, the department is not willing to go for mediation.
On the respondent department not agreeing to the matter being referred for mediation? The same is now seem to be listed in due course.
Much obliged. Item
So
number...
21, 22 same.
Yes, Your Lordship, there's similar matters. Item number 23.
May it please Your Lordship. Your Lordship, here the parties had tried to sit across the table, so Your Lordship, however, that was unsuccessful.
Okay.
And here, Your Lordship, we have been directed to file our points of argument, Your Lordship. I believe the matter is coming up next week, so
Okay,
let the matter be heard, Your
Matter has
Lordship.
been heard.
Your Lordship, yes.
So since the matter has already been heard, accordingly, parties are not inclined to refer this matter for mediation at this point of time. This the case in due course.
Obliged, Your Lordship.
Item number 24.
Lordship, I will require some instructions regarding this mediation.
What is this matter about?
This is a promotion matter.
Motion, Your
Lordship.
Lordship.
Promotion.
Just give us 1 week time. Lordship.
Are there private respondents?
No, Your Lordship.
Yes, Miss, you
Here,
just
Your Lordship, the petitioner has already retired.
He's just seeking for national promotion. Lordship.
They're asking for retrospective promotion, Your Lordship. So,
even then, if it can be worked out,
Your Lordship.
do it.
One instruction. Lordship.
We'll refer the matter for mediation and see.
Your Lordship.
So, parties have agreed matters to be referred to mediation. So I have to see order.
Obliged, Your Lordship.
Item number 25.
Yes, nobody is appearing. Pass over the
On supplementary list, item number 1.
Yes, some clarification. Well, it's before my learned senior begins on this issue. I think we filed an additional affidavit bringing a report that had been filed by the police before this court in the writ matter, Malits. I brought it on record in the bail application, Malits. I don't think your lordships will need to look into anything further. What was the...
Is this the one?
Malits, if I may just draw your lordship's attention to the report, Malits. This has been filed by them in the writ petition. It's Annexure 2, page 6 onwards.
Yes.
Factual record, if my lords kindly have a look at it. That on 27/1/2026, the accused Gopal Krishna Gaur, alias Gopal Krishna Gaur, was apprehended from Guwahati Airport. Thereafter took him to Khanapara PS. Upon his arrival, the accused was duly informed of his constitutional rights. He was so and so. My lords, what we've been submitting from day one has now come officially on record before my lords. That on 27, my lords, he was actually apprehended in Guwahati Airport. That, my lords, is in the jurisdiction of another state. He was neither produced before a judicial magistrate in Guwahati, nor was there any warrant of arrest, my lords, authorizing his detention there. So, what essentially comes before your lordships is, my lords, this is a pure case of an illegal arrest by the police. I don't think there is any denial of this after this statement has been filed.
So what else?
I'm sorry, my lords.
What else?
Well, that's number one. Number two, my lords, the present position of the accused, my lords, as per my instructions, is that he is admitted in the ICU of Negrims, my lords.
Okay.
So he was referred by that hospital to Negrims, and he's in the ICU of Negrims, subject to what my learned senior says, my lords. I'll just apprise your lordships. But my lords, this, in my humble submission, would essentially settle the matter insofar as the detention of the accused person is concerned. And my lords, we've also annexed the remand, the first order of remand. He is arrested on the 27th, my lords, in a third place. First produced before a court on the 28th. That also in Nongpo. So, my lords, the very fact that he was arrested in Guwahati and not produced before a judicial magistrate in Guwahati and he was forcefully brought into Meghalaya itself, my lords, vitiates the entire arrest. That's my humble submission before your lordships. And the law is very well settled, my lords. If your lordships so please, my lords, we'll just place one authority on this issue. But the law is very well settled.
You said you'll file your written notes. Have you filed?
No, notes are ready, my lords. We'll file it. We'll just serve a copy on the state and just file it, my lords.
We'll file it, your lordship. So we'll file.
You do it in course of the day?
Yes, my lords.
In fact, it's ready, your lordship.
Or counsel for parties? Submission is made that written notes of
can't say
argument
that
will be
again.
filed in course of the day. Orders to I issue. If I can pass the order today, I'll do it. If not, I'll reserve the order. It depends on how soon you can.
We'll file it, my lords. My lords, I don't think the state is denying the fact that he is in ignorance. Lordship,
So be it.
well,
If that is correct, then
because he's in their custody, my lords. He's still in custody.
what you say is correct. Then
I will not. I will not
I
make
will
a.
assume also that is correct, your lordship.
I will not make a false statement before your lordships.
Correct. On what count?
Well, but this, my lords, actually reflects on the high-handedness of the police. This cannot be permitted to. That's my humble submission. Irrespective of, my lords, which side we are standing on. But sometimes, my lords, these police excesses has to be curtailed.
Provided that you are a law-abiding citizen, your lordship.
Anyway, the parties have mostly submitted on procedural.
It's more of a procedural issue.
Procedural issues or defect, whatever.
My lords.
But none have, made any submission as regard the issue involved or the merits of the.
My lords, on merits, my lords, I submitted on day one. If your lordships would recollect,
On
my
merit
lords,
also have made a submission, your
I have
lordship.
pointed out, my lords, that all these offences are punishable with imprisonment for less than 7 years, up to 7 years, my lords.
Yes.
So, as the law is, from Arnesh Kumar onwards, that in these kind of cases, the custodial detention of the accused is to be resorted as a last measure. If at all there is a written note, by the IO has to note down, why the custodial detention has to be there. That, again in this case is not available. We'll put it in the written notes of argument. That's on the merits of the matter, because otherwise the matters at the stage of investigation.
Okay. This relates only to a particular case.
Yes. One case,
Yes.
This is that Khanapara PS case number 35-7 of 20. 25? Of
25/7 of 24.
24.
Can they list item number 1?
Highly obliged.
Highly apply, Your Lord.
Please show me the notes, finalize it.
I suka tuka.
May I please, Your Lordship? Your Lordship, can this matter be please come up after 1 week since the conducting counsel who's from Guwahati could not appear due to personal difficulties?
May I please, Your Lordship?
Have you filed your counter?
Yes, Your Lordship. We've already filed an item number 2.
Oh,
Your
they are
Lordship.
supposed to file rejoinder?
No, Your Lordship, they have to file an
No,
an
sorry.
opposition.
Yes. Sorry. They are also responding.
Yes, Your Lordship. The petitioner, they have to file a rejoinder, Your Lordship. in this matter.
Yes. Who is appearing for petitioner? Have you filed your rejoinder?
No, Your Lordship, if you want to receive the affidavit in opposition by the respondent file, you will be kindly put together.
Yes, the counsel has sought for accommodation on behalf of Mr. I. Bora, Leonard counsel, who is conducting the matter and who is said to be indisposed for the day. On behalf of respondent 5 Moto. Accordingly, as prayed for, release this matter up to 2 weeks.
May I please, Your Lordship? Your Lordship, item 1 and item 2 are connected matters.
Same order.
Thank you.
Item number 3.
I'm entering appearance for the respondent number 1. I'll be filing my power in the course of the day.
Yes, you appearing?
I put appellant, Your Lordship.
So, state your case. Yes, what is your case? Tell me.
This is to set aside the can quash the impugned order, Your Lordship, by the additional district judge. Your Lordship.
What are the facts?
It will be taken up at the next date, Your Lordship.
For 2.
This is the first appeal
Oh, my lord.
Yes, Your Lordship.
of probate.
Yes, my lord. They've assailed the rejection of the probate. This appeal.
So we'll admit the appeal. Paperwork to be prepared. Evidence have been led in this case.
Yes, my lord. Evidence is there.
Heard, Mr. Leonard counsel for the appellant. The respondents have also been duly represented. Let's stop
For admission.
for respondent. Who is for respondent number 1? You're for respondent.
I'm for the respondent number 1.
Mr. Stop, no, Mr. K.C. Bhutam, Learned Counsel, has entered appearance on behalf of respondent number 1. Mr. You are for?
2 and 3.
Mr. Learned Counsel has entered appearance on behalf of respondent 2 and 3.
And I am for 4.
And Mr. P.K. Bora, Learned Counsel, has entered appearance on behalf of respondent 4. Accordingly, all the respondents are in attendance. It is the submission of the Learned Counsel to the appellant that being aggrieved by the judgment or order dated 8/10/2025 passed by the Learned Additional District Judge Shillong in test probate number 3 under bracket H of 2010. This this appeal has accordingly been preferred. It is further submitted that there are good grounds for this appeal to be admitted and heard on merits, and as such the same is such prayer is made for admission of this appeal. Learned Counsel for the respective petitioners has no objection to the admission of this appeal. Since appeal is a statutory right, accordingly, on consideration of the submission made and on perusal of the memo of appeal, this court hereby admits this appeal. The trial court's record I hereby call for. The appellant is directed to prepare and file the paperwork on receipt of the said records. This is matter of the 3 weeks.
3 weeks, please.
3 weeks.
Item number 4.
Lovely.
Lordship, I have concluded my hearing on the last occasion. Now in item number 10 and 11, these are the teachers claiming for salary. So as per the last order, the government is supposed to file some instruction, Lordship. Item number 10 and 11, Lordship. And so far as item number 5 to 9, they can argue, Lordship.
Yes.
With regard to item number 10 and 11, for filing affidavit, this matter has been handled, led by the senior counsel, AAG. But
Your Lordship, in item number 10 and 11, we're still awaiting instructions, Your Lordship.
That is for payment of their salaries.
Yes, Your Lordship. We were supposed to file an affidavit, Your Lordship, so I'm praying for some time.
What was the initial affidavit?
The initial affidavit, Lordship, then there was a supplementary affidavit till 2019, Lordship, February. They have brought on record that salary has been paid to me, Lordship. Now, after that, Lordship, 2019, that March onwards, where the salary is going, the court has directed the state to file an affidavit, only specific, with regard to the specific query, Lordship. On record 2019 March, Lordship, the state has filed the additional affidavit. They have given the chart that the salary was given to me.
Till 2019?
Lordship, February 2019, Lordship. March.
You have filed this case in 2018?
18, Lordship.
That is, with a prayer for payment of salary.
Salary for some periods until date, Lordship. Till date.
So till then, thereafter the government has paid you, or the authorities have paid you salary for till
salary,
2019?
Lordship, February 19, Lordship.
And from
February 19.
And from February 19?
March 19 onwards.
Or March?
19 onwards, yes, Lordship.
Not
Lordship.
So in the meantime, what has happened? Have you filed, additional affidavit? Or?
Yes, Lordship. That is why my Lord has asked the government that where the money is going, Lordship.
Since 2019, when your salary was not paid, since March. See, now we are in 2026.
26, Lordship.
What have you done?
Lordship, now since the matter is pending, now their claim is that
there was an order by this court.
Yes, their claim is that I am not the sanctioned teacher.
Okay.
So now the record shows that from 2016 to 2019, Lordship, this is the government affidavit that all throughout the pay statement was made in my name. The teachers also sent for BA training from the school, Lordship. There are lots of documents.
That is on merit.
Yes, let's merit. Now that is their because the salary is to be given to the managing committee, not me.
Oh.
And till February 2019, the salary was given to me directly, because that is one of the recommendations of the inquiry committee, Lordship. My Lord may recollect that the genuine teacher's salary should be directly credited into their personal accounts. So accordingly, the salary started to the state respondent started to give into my personal account. Subsequently, there is a change of district school education officer as well as the managing committee was restored, and the principal was also restored. Then the problem again started. Then the salary is given to the managing committee, not to the concerned teacher, Lordship.
Have you filed, you clarified all these points?
Your Lordship, we are seeking instructions with regard to this point. So, Your Lordship, I'm praying for some time because instructions are being awaited, Your Lordship.
Fine, we'll wait for instructions. What can we do?
Lordship.
You just have to confirm.
Yes, Your Lordship.
Whether the salary was disbursed through the managing committee.
The salary is sent to the managing committee.
Or not. Whether it's still in your account. We are not saying that at this point of time, perhaps,
yes,
we are not saying whether the petitioner is eligible or not.
Your Lordship.
But if it has been done so for a considerable period of time, then why would you
Your Lordship.
Stop. Anyway,
Lordship, in item number 9, Lordship, because there is an order, Lordship, is okay since they are asking for time. So far as item number 9 is concerned.
fine. We'll pass order in 10.
10,
11.
there is an order, Lordship. Yes, Lordship.
I took a 10, 11. Oh, yes, you are supposed to file your status report.
Yes, Your Lordship.
Not yet. Mr. Leonard G.A., appearing for the state respondent, has sought for some more time to comply with this court's order dated 5/2/2026, inasmuch as the status report required to be filed could not be filed today, as specific instructions are still awaited. Specific instructions from the department concerned are still awaited. Accordingly, as prayed for, let the said status report to be filed by way of an additional affidavit be placed before this court within the next date fix. Took a date, but I ada that's for 10, 11.
10 and 11, Lordship. In item number 9, Lordship.
Now, 5 onwards, you've completed your...
Yeah, I have completed my...
So, who is to start?
Now...
You are there.
Your Lordship, Mr. Shula is leading the matter, Your Lordship. Since we've prayed for time in item number 10 and 11, and since the matters are tagged together, Your Lordship, I'm praying let the matters come
But that is
together.
a different issue. 10 and 11 is a different issue altogether.
It's a command all throughout, my Lord. They are challenging the action taken by the managing committee, by my party. And throughout all these petitions are tagged together. And only that aspect, solid aspect, Lord should direct them to give us status report. Otherwise, all throughout, my Lord, my learned Esteem friend also argue the matter together.
Yes, Your Lord.
So if we segregate, my Lord, there will be. So if your Lordship permits, matter may come after 1-2 weeks. In the meantime, let them place it. And here the matter.
So, all matter, Mr.
That is true, my Lord. From our side, we never. My esteemed colleague has time to argue the case 2-3 minutes. From our side, we will not take them seriously. We will argue, my Lord. Short and brief.
Okay, we'll fix a date then. You said just a date.
Your Lordship, let it come after 2 weeks, Your Lordship.
Not 2 weeks. What week will be? No, today is 19th.
19th, Your Lordship.
Happy afternoon, Friday. One case now. Friday afternoon. Di biru dah deh. Tapi kisah ham keluar apa yang kini kiu? Pok ni kata yo. Aku San
Dan DB.
Oh, San dan DB. Apa riu? Okay, we'll have it on 27 then.
Your Lordship.
Ketua date 10, 11 mo tu.
Can we make it 26, Lordship, 27?
26, we have a quite number of...
All right, Lordship, all right.
We may not be able to...
All right, Lordship. All right, Lordship, no.
Ms. Larat J has submitted that the reply by the state respondent may be could not be done so today, as the Larat AAG, who is leading the matter, is indisposed Similarly, the respective counsel for the other respondents have also made similar prayer. Accordingly, on prayer so made, matters adjourned. Hearing to continue on the next date fixed. This is matter on 27 for the hearing. 27.
Right, Your Lordship.
My lord, in item number 9, lordship, there is an admitted case, lordship, here on the last time when I have argued that matter, item number 9, lordship. Here there is an order because some pending salary is due, lordship. Now that petitioner item number 9 has been terminated on the ground of fake certificate, lordship. Now prior to that, some pending salary were there, lordship. Now the contention of the government was that the concerned DSEO, that salary, the pending salary cannot be disbursed till the outcome of the criminal case pending before the JMFC, the Dingri, lordship. Now that case has already been closed, lordship. That means the accused, that petitioner herein was discharged from the liabilities of the case. So the government can get the instruction with regard to that case also, lordship.
No, then in that case you file an application. File an application to the authorities.
Oh, all
bring
right.
all those on record.
All right. I'll do, lordship. That.
Those are not facts
Yes.
brought on record in this case. They are subsequent developments.
Oh, all right. I'll do that.
Okay. Thank you.
Item number 12.
Wait, please, Your Lordship. Your Lordship, in this matter, we were supposed to get instructions with regard to the disbursement of funds to the Janja Hills Autonomous District Council, Your Lordship.
Oh.
Your Lordship, as per my instructions.
Pensionary benefits.
Your Lordship.
Is it pension?
This is your lordship. I'm sorry, your lordship. Lordship, kindly have our instruction, your lordship, on the next page.
Yes.
If lordship kindly have year 24-25, your lordship. Lordship, kindly see from mining and geology department, your lordship, we have given the discouncil around 97 crores 5,17,214, and then lordship, for the year 25-26, from mining, your lordship, 56 crores 10 lakhs 52,000, and then from the forest and environment, 22 crores 9871 777, your lordship. Then from transport department, 11 crores 986 10 lakh. The total amount which have been given by the state, your lordship, to the district council so far, the share of the share from transport, mining and geology department, your lordship, and forest, your lordship, it comes to around 90 crores 95 lakhs 34,709. So the contention all along of the district council, your lordship, that we cannot pay the writ petitioner, the pensioner, your lordship, because money is not coming from the state, is absolutely misleading and not correct, your lordship. This is the figure, your lordship.
Yes, who's appeal?
Your Lordship, may be kindly allowed to take instructions on this.
You file this, Mr. Sulek, file this by way of an affidavit then.
Lordship, yes.
Because it has to be on record.
Lordship, in fact, this is issued by the from the district council office department of the state, your lordship.
Exactly.
I believe it's a genuine document, your lord. If lordship can, lordship also can take judicial notice of it also.
Because they have to be given copy.
Lordship, we can keep them a copy also, your lordship. If lordship will file it by an affidavit, we have no problem, your lordship.
Because you see, these statements are annexures here.
Lordship, yes.
Oh. Yes, Mr. Silla.
I'm here, my lord.
Have you?
My lord, it's really shocking, my lord, because all this while the district council have been saying that they don't have funds, but if what the learned additional advocate general have stated, my lord, is correct, then perhaps an affidavit is called from them also to explain, my lord, where have they kept all these funds all this while? Because all this while, as per the RTI that we have filed, it takes only 50 lakhs rupees per month to pay the monthly pension of all the pensioners, my lord. But they are getting substantial money of 90 crores, my lord. So it's for the district council to really clarify on this, my lord.
Exactly. That is why you must be in receipt of this, but you respond. Mr. Andy Shulai, Leonard AG, has produced communication number dated 16 February 2026, issued by the Under Secretary to the Government of Meghalaya upon the Learned Government Advocate, Ms. Soso, wherein is annexed a statement of money released to the Jaintia Hills Autonomous District Council with effect from 2021 till date, till 2026. However, the Learned AG has submitted that he may be allowed to file the said communication by way of an affidavit to allow the relevant respondents as well as the petitioner to respond to the same. As prayed for, let the said additional affidavit be filed within the next date fix with advance copy to the petitioner as well as the respondent GHADC. This is matter
after 2 weeks, your lordship.
After 2 weeks.
Lordship. Apply, your lordship.
Item number 13.
What do you do?
My lord, today speaks for my reply, short reply, the land acquisition matter, the first appeal filed by the cooperative bank. My lord, my esteemed colleague has already given the reply. I would prefer to give a short rejoinder today, if lordship permits me. And after conclusion, if lordship permits, may we be allowed to give a short notes. Okay. For lordship easy reference. Now, the issue involved in this appeal is, my lord, the market value, my lord. The market value under the Land Acquisition Act, the repeal Land Acquisition Act 1894, under Section 19, Section 11, collector can determine the market value. And the date of, my lord, the market value would be determined from the date of Section 4 preliminary notification.
Yes.
Now, in this case, my lord, in 1987, Section 4 notification was issued, my lord. But the collector passed the award in 1993. And when collector awarded the, given the award, my lord, the claimant produced the 1991 sale deed. 1991 sale deed. And, my lord, that was placed, but the collector fixed the award at the rate of 80 rupees per square feet in Buddhist Bazaar. So if we compare, my lord, the present rate, that is absolutely too minimum. But in those days, my lord, that economy in those days, my lord, that was quite reasonable at that point of time in the eyes of the collector. So 80 rupees, they refused to accept, they received under protest, made the travel off and on to High Court and the Supreme Court. And finally, the matter went to reference court, and reference court decided the matter. Now, reference court say that the market value would be, well, at the time when they issued this corrigendum in 1991. In 1991, corrigendum was set aside by the High Court that time. So the issue would be whether the market rate fixed by the special court today over and above 10 times of the rate fixed by the collector is correct. Number two, my lord, the limitation period for filing a reference, my lord, that also there, my lord. So I would give, my lord, and the judgment placed by my colleague for the claimant, I would place that one. If I may place in the copy also, Lord Shiva, last occasion he has submitted. Well, at the 2013 volume 4 SSC. 2013 volume 14 SSC.
Volume 4 or 14?
14, my lord. SSC page 195.
195.
My lord. Copy has been supplied by my colleague. Early occasion. Mr. Listy.
100. That copy has been.
My lord, copy has been served upon us also after serving the copy to my lord.
Yes.
In the last year. Now, in this case, what happened? I've gone through the judgment. There were successive Section 4 and Section 6 notifications. So, Supreme Court held that today Section 4 notification is issued. The next week, my lord, government issued another Section 4 notification for the same plot of land. It is implied that government has superseded the first one. So, the collector has to calculate the market value on the date on which the second notification is issued, the next week. This is undisputed, my lord. So he relied on that, my lord, saying that, my lord, Section 1987, Section 4 was issued. But subsequently, Section 6 declaration was issued in 1991. So they are referring to that way, my lord. But Section 6 has nothing to do with the market value. Section 4 is the relevant one. And admittedly, they are not disputing. Section 4 was issued in 1987. State did not dispute, the collector did not dispute, even claimant did not dispute. But the fixation, my lord, fixation by the collector, by the district judge, is based on 1991. So, according to me, my lord, here there is no successive notification. Only one Section 4 notification. And Section 6 notification, there were subsequent notifications are there, in view of the intervention by the Honorable High Court 10. Now, therefore, this judgment is not applicable in the present facts and circumstances of the case. My lord, I'll just shortly, my lord, refer to paper book, my lord. Got it?
Yes.
Paper, page number 1, that is a Section 4 notification. This was issued on, my lord, 30th June 1987. The first page it is.
26 June.
38 June, my lord. Page number 1.
Yes.
38 June 1987. Page number 1 of the paper book.
Page 1 is there.
Page number 1, Lordship.
38. Okay.
38, my lord. And Section 6 declaration, the next page number 2, 14 January 1988. 88.
14 January 1988.
88. That is page number 2. Page number 2. And Lordship, the area of acquisition is 480 meter. That is a 5,000 square feet almost. And the claimant went to High Court, and the High Court passed an order, page number 3, 1991, and directed for reducing the area, page number 6. I'll not take the other annexures. only the important I'll refer to, just
Page
number 6, para 12. By this order, my lord, High Court directed the collector to reduce from 480 square meter to 300 square feet for acquisition. That too on the request of the claimants. So accordingly, the corrigendum was issued, page number 20. Page number 20, this is relevant, my lord. Here the collector, the special officer referred to this and relied on this. Page number 20.
Yes.
Corrigendum, my lord. 23rd December 1991.
Only with regard to the reduction of the area.
Yes, area. And lordship, the content is very interesting, my lord. It says, please read.
Yes.
Please read 3,000 square feet in place of 480 square meter appearing in the department's notification. 30th January 1987 is the section 4 notification and declaration 1988. So this is a correction of the area. It is not the supersession of the earlier section 4 notification. Now, later on, my lord, the next page number 21, they issued a section 6 declaration. It was issued on 4th January 1993.
Okay.
And being aggrieved with this, again, my lord.
So there are two section 6 declaration notification.
Yes, section 6, new section 6 declaration was issued mentioning 300 square meter. So with regard to section 6, my lord, there are second section 6 notification.
Yes.
So earlier section 6 notification 1988 was superseded.
Exactly.
Yes. And this, my lord, page number 21 notification 1993 was also again set aside by the as well Guwahati High Court. My lord, we come to page number 22. At the instance of the claimant, page number 22, judgment number 23rd August 1993. In the relevant para, may I show, my lord, page number 33.
Yes.
So, page 33, point number 1, the notification dated 23rd December 1991, that is the corrigendum.
Yes.
And 4th January 1993, this is a section 6 notification, were quashed.
Yes.
It was quashed. And directed for, my lord, number 3, point number 3, very clear. The survey shall be completed within 2 weeks from the date of the receipt of the court order of this judgment order, and 2 weeks thereafter completion of survey, the state government shall publish a fresh notification in the nature of section 6.2. Section 6.2. So High Court directed for fresh section 6 notification. Accordingly, my lord, page number 35, section 6 was issued again. That was issued on 19 September 1993.
Yes.
So, my lord, the facts appear there was no second notification with regard to section 4. Section 4 notification in 1980 stands remain. But the section 6 declaration in 1988 was then superseded by the subsequent notification, that is 17 September 1993. Thereafter, my lord, I may come to the judgment of the learned court below. My lord, may kindly straight we come to page number 282. 282. Now the claimant's assessment was, my lord, it should be, my lord, 1,200 per square feet.
Yes.
Should have been awarded by the collector. So that was the contention. But the court below, my lord, page number 282, in the middle paragraph, my lord, none of the other claimants could substantiate that the price of land was rupees and such. Now, as per sale deed, exhibit number 2, that 31st December 1991, I will show that one more. The plot of land situated Police Bazaar measuring such and such square together with structure was sold for a price of 6 lakhs. That is at the rate of 599 per square feet. That including the cost of the land and the structure. Now this is very relevant, my lord. Now the special officer, judicial officer has given 800 over and above this one also. Now, I would come to, my lord, page number 283, the next page. In the middle, as per the sale deed, my lord, as per sale deed exhibit A dated 1988, the plot of land measuring to 3,000 square feet at J Road, Shillong was sold for a sum of rupees 4,500 and such, that is at the rate of 15 per square feet.
Yes.
1980. That was the prevailing market rate. However, collector has given 80 rupees because he determined in 1993. So that was our contention. Well, that was the prevailing market rate in 1988, that point of
1988.
1998. Now, second, as per the sale deed, sunset 1989, the plot of land measuring sunset and sunset with 2-storied RCC buildings standing thereon.
This is in Jail Road, no?
Jail Road. And the acquisition here also Police Bazaar. Same area.
Jail Road and Police Bazaar are two.
It is a different locality, but it is in the same. Well, it is a vicinity. It's a close vicinity. So even assuming that Jail Road here, the market rate would be Police Bazaar that time. Calculation with the structure, with the building, it was 383 per square feet.
Okay.
Now the special officer has awarded 80 to 800. Now page 284, that paragraph may come. So special officer, judicial officer understood what was the prevailing market at that point of time, 88, 87, but ignore it, And now, page 284, in the middle paragraph, notice under section 4 was issued by the government of Meghalaya, by notification which was published stating that more than Police Bazaar with boundary described in the notification was to be alienated for public purpose, namely for construction of Shillong Cooperative Urban Bank. However, by a later corrigendum, the amount of land sought to acquire was refixed such. Subsequently, declaration 1991 was issued and published in the Gazette 1991 for the purpose. Now, this were already not set aside by the High Court. Therefore, it says the rationale of the special officer is this manner.
Yes.
Therefore, the relevant date for computing the market value of the land should be reckoned from 23rd December 1991 when the corrigendum was issued. But this corrigendum was already nullified by the High Court. It was non-existent.
Okay.
In this regard, it says, the sale deed at Exhibit 2 would be relevant for the purpose of arriving at the market value. Now, the Exhibit 2 is available in page number 147. But should we go back once? 147. Page number 147.
Yes.
Well, page 147, second paragraph, kindly see, it is not the land alone. It says, whereas the seller is lawfully seized and possessed of and otherwise well and sufficiently entitled to the plot of land, together with a shop house standing thereon situated Police Bazaar, GS Road, and the total amount is mentioned by the next page, 5 lakhs. So this is the cost of land and the structure. It comes, my lord, 599 per square feet,
okay,
combined together. So the special judicial officer is relying on this. And this one also, my lord, 599 per square feet it comes. She has already calculated in her own judgment also.
Okay.
And this was issued in 1991, registered in 1991. But whereas Section 4 was already issued in 1987. But anyway, assuming that, my lord, she ignored, my lord, court below ignored 1987 Section 4 notification, but rely on this, but completely fail to appreciate the fact that this is the cause, 5 lakhs is the cause of the land in the plot, the land in the structure.
So the comparative market rate at that point of time would be 599.
599.
600, whatever.
Yes, for both land and the structure.
For both land and structure.
For land and structure. But here the special officer, my lord, in the subsequent page.
You have acquired land and structure or just land?
Only land. Only land, and one Assam type house is there. One Assam type house there. And therefore she has awarded 2 lakhs something. We have no grievance with that. We have no grievance with that. We are only concerned with the land, cost of the land. So, my lord, we can come to page number 284, the same page. So, the last line, my lord, therefore, considering the materials on record and the location of the land in question, it says.
Yes.
My lord, this court is of this considered view that market value of the land would be rupees 800 per square feet. We agree with this one.
Yes.
So even if I rely in 1991 sale deed, it did not come with this. And this is more than 10 times of the award given by the collector. Collector given 80 rupees per square feet. Now, in view of this, my lord, the last page, my lord, page number 288. In the middle portion, my lord, page number 288, the claimant is thus entitled to a total compensation of rupees 26 lakhs. Such. And structure standing thereon. After adjusting the amount already paid, the claimant is entitled to a compensation of rupees 22 lakhs. Now, in addition thereto, the claimant is entitled to a solution of 30% on the enhanced amount along with interest at the rate of 12% with effect from the date of publication of Section 4. Now, the contradiction here, madam, this interest would be with effect from Section 4 notification, that is 1987. Therefore, we agree with the amount that the trial court completely overlooked the prevailing market value at that point of time. And the documents relied on was admitted as sale deed after Section 4 notification. Number 1. Number 2, therefore it is bad in law. Secondly, even assuming that learned court below can rely 1991 sale deeds, still then the calculation made by the court below is absolutely irrational.
Even in 1991 it would be 600.
1991 also it says, along with the structure and the land, it is only 599. We can say 600. So at the most maybe 300 or 400, excluding the cost of the building. So definitely this is therefore, we agree with this. With regard to the building, the cost of the building arrived at by the collector, by the court below, we have no grievance, my lord. We are not agitating that point. We are ready to give. But this one, my lord, the cost assessed by the trial court below is absolutely irrational without any evidence, my lord. So the rest, my lord, we sum up with the gist of the notes. Allow us to prepare within 2-3 days, my lord. Okay. And along with the judgment.
So, heard Mr. Sangrisu, Learned Counsel, Learned Senior Counsel, for the appellant, who has made his submission as rejoinder to the argument tendered by the respondents. On completion of the arguments, by the parties, it is prayed that written argument, modes of written argument may be allowed to be filed. Pray aloud. This is matter of 2 weeks.
Upright.
Item number 14.
My lord, here oral argument has already been completed. On the last occasion, my lord, this is an MSc appeal, my lord.
Yes, yes.
So on the last occasion, they have filed synopsis. So I have just responded. I'm filing it today, my lord. I've given the copy to them.
Yes.
Except that I have annexed one judgment, Your Lordship. Earlier, I have already submitted 3 judgments. Here in this synopsis, I have just annexed one judgment, Your Lordship, which is regarding pay and recover.
Okay.
I have mentioned.
You file your written argument?
Yes, Your Lordship.
Mr. Ahmed Suri, Learned Counsel for the respondent number 1, has submitted that the synopsis of the argument on behalf of such a respondent has been filed today. Accordingly, that is reserved for judgment.
Obliged.
Second call, item number 25.
Your Lordship, I'm sorry, actually, in this, I could not submit this paper book. So kindly give me 2 weeks' time, Your Lordship, please.
No, this is for mediation.
Mediation.
Which one?
Temporarily.
Mediation?
Are you willing to for the matter to be referred for mediation?
No, I don't think actually at this stage it cannot be.
Why?
Because our claim is more actually, and the insurance will not actually incline to do that.
Oh, when you have not even tried, how can you say?
If your Lordship thinks it is fit, then it can be sent.
Let it go, and we'll see.
All right.
Because parties have agreed for matter to be referred for mediation. Accordingly, let this matter be put up before the mediation committee for appointment of a mediator and appointment of the mediator and the process thereof. We'll see how it goes.
Yes.
Otherwise, see,
no harm.
As far as claim is concerned, it's always good that parties come to some settlement, or otherwise it will be a long drawn out matter. If not from here, it might go to Supreme Court, it might come back. You never know.
Maybe there's chance.
Okay.
Much obliged.